Order! Order, the House is now resumed. A point of order, Valerie Vaz.
Thank you, Madam Deputy Speaker. Can I just clarify my earlier point of order on motion 4? I understand there have been further discussions with the government and the opposition, and I'm rising here to withdraw our amendment because I understand a new motion will be put down on proxy voting tomorrow.
I'm grateful for the Honourable Lady's point of order and for her clarification, so I will do my arithmetic again. Having started with 3 amendments, I now have 2 withdrawn, so there is 1 amendment left. I'm grateful to the Honourable Lady. Thank you. Under the order of the House of today, we now move to Committee of the Whole House. Order. Before I ask the clerk to read the title of the bill, I should explain that in these exceptional circumstances where the chair of the committee stage would normally sit in the clerk's chair during the committee stage, in order to comply with social distancing requirements, I will remain in the Speaker's chair during this committee stage, although I will not be carrying out the role of Deputy Speaker, but that of Chairman of the committee.
Corporate Insolvency and Governance Bill.
Thank you. We will start with Amendment 1 to Clause 1, with which it will be convenient to take all the other clauses stand part, including amendments to clauses and new clauses, and all the schedules, including amendments to schedules. I call Lucy Powell to move Amendment 1.
Thank you very much, Madam Deputy Speaker. It's good to be back here again so soon. I beg to move Amendment 1 in the names of myself and my honourable and right honourable friends. I will speak also to the other amendments and selected new clauses in our names. As my right honourable friend, the member for Doncaster North, and I have already said, we support the principle of this bill and have urged the government to do more to support businesses so that they can remain solvent and don't need to use these provisions. Turning to the provisions before us, I hope the Minister will take these in the constructive way that they are meant. I will speak to each of the amendments in turn and set out why we are seeking reassurances or think that the government should consider changes to the bill as it progresses. This has been a very truncated process so far, so we are relying on Ministers' goodwill to take on board not just those comments that I'm about to make, but those that have been raised in the second reading of this bill, some of which I thought were really excellent suggestions. Taking the self-explanatory amendments first, this set of amendments from Amendment 3 to Amendment 12 inclusive would extend the time limits of the COVID-19 specific members in the bill. We welcome the retrospective nature of the provisions in this bill, yet as we have discussed with the Minister, we suggested that the government amend the bill to extend the time limits for a number of the provisions as they are insufficient given the prolonged nature of the crisis. Specifically, the suspension of the wrongful trading liability and statutory demands and winding up petition measures should be extended to the same date as when the AGM and company account filing measures are valid, which is until the 30th of September. Clearly, there was a sense from government when this bill was being drafted that on the 30th of June, most things would be back to business as usual. Yet it's now clear that many sectors won't even be partially open for business again by that deadline. And I'm thinking particularly of hospitality, travel and tourism and the arts and their associated supply chains. These won't even really have begun trading by the end of this month, let alone be getting back to any kind of solvency.
On that point.
Yes, give way.
Honourable Lady for giving way, and I agree wholeheartedly with what the Honourable Lady is saying, because in Northern Ireland the start date for the hospitality sector for hotels is the 30th of July, so nothing will even be in place until that time. So I'm just a wee bit disappointed perhaps maybe that the Minister hasn't acknowledged the fact that we really should have the 6 months already beyond that again, and maybe even to the end of the year.
Well, my honourable friend makes a very good point. And I think it's also about businesses that are struggling to keep their heads above water also need to have the certainty and the lifeline measures in this bill, and they need to know that they won't be pulled away from under their feet before they even reach needing them. Indeed, the point of the suspension of the wrongful trading elements of the bill is because lots of businesses are effectively trading technically insolvent already through no fault of their own. And just as we've seen ministers extend, rightly so, and to be welcome, the furlough scheme and other support for the self-employed and other measures, they should get ahead of this now, rather than having to spend time with a statutory instrument in only 2 or 3 weeks' time. Ministers could and should take the opportunity to get this done today and agree to our amendment. The extension moratorium for small businesses. This amendment would extend the moratorium for small businesses from 20 days to 30 days for businesses facing insolvency. The FSB have called on government to extend the moratorium period for small businesses because they don't believe that 20-day time period in the bill is sufficient, and we support these calls and we ask ministers to agree to this change. Going over to new clause 2, Madam Deputy Speaker, oh no, we don't say Madam Deputy Speaker, do we? Madam Chair, sorry. As this is not included in the selection, safe to say that I think we will have a proper look at this in the other place. But we do think that the Small Business Commissioner should have their powers strengthened, and we heard much of this discussion in the second reading debate. We've long argued for some of the permanent measures in the bill, particularly in the wake of the Carillion collapse. However, we do have some concerns about what has been left out, as I said in my second reading speech, and there could be unintended consequences in the restructuring proposals that are being put in place, which could disadvantage small businesses or employees or other unsecured creditors such as pension funds. And this is a point that the Minister and I have discussed in private as well, and it was raised by a number of opposition of government members earlier this evening. And whilst we appreciate the haste in bringing forward these changes, given the crisis and the numbers of businesses struggling already, we are concerned that members in this House and outside bodies have not had a lot of time to scrutinise the bill and its implications, and so we think that having a reflection period and a review period is something that the government could consider. There are a number of omissions from the 2018 consultation, which we've included as amendments. The collapse of Carillion and the consequences for workers, supply chain businesses and the public was a national scandal and an abject failure of British corporate governance policies. There have been huge repercussions for the taxpayers, with unfulfilled contracts, unfinished buildings, thousands of apprentices laid off, and the taxpayer had to foot the bill for these corporate governance failures. And there's rightfully public anger at the failure for people to be held to account for such things. As ever, it seems that the profits are taken by the private sector in such instances, but the public sector foot the bill when the risks are being taken by directors over which they have no control. And it's clear, given the economic crisis we face and likely recession, that in the next few months and years we're going to see more big corporate collapse and failures. And therefore it really is remiss of the government not to strengthen the corporate governance measures as they said they would do in 2018. And I just want to make clear, especially because members raised this earlier this evening, that the measures in our amendment are measures lifted entirely from the government's own recommendations. Alongside key omissions from the bill, we've heard from trade unions, academics and other organisations about some of the sweeping powers in the legislation and the fact that there could be considerable scope for misuse of these measures to disadvantage particular groups. The next set of amendments would seek to safeguard funds for unsecured creditors, protect pension schemes and protect employees by giving trade unions a voice in any restructuring plans. I really would urge the Minister to have these conversations with the trade unions and to look to add this provision or a provision like it as members from both sides of the House were calling on earlier as this bill progresses to the other place. We do have concerns about how the restructuring plan will hit employees. Many more could be pushed to or around the national minimum wage, lose their rights and their wages, as we've seen at BA at the moment with what they're doing, British Airways. Pension scheme deficits will be left unaddressed, and more workers could end up losing out from their pension schemes as well. So if this wasn't an emergency bill, we would have had a lot more time to probe ministers on these issues in full committee and discuss what could be done to strengthen the protections in this bill. New Clause 1 inserts into Section 176A of the Insolvency Act 1986 a requirement that at least 30% of the proceeds from the sale of assets of businesses in administration and liquidation shall be ring-fenced for the payment to unsecured creditors. Unsecured creditors often end up losing out to other larger creditors, such as banks. This new clause explores a way for unsecured creditors to be guaranteed some assets so that they don't miss out. The proposed legislation assumes that all creditors are identical and take a hit, but we know that in reality this is not how this is borne out. There is a case of protecting SMEs and other unsecured creditors. Debts up to a specified amount and should not be reduced. So what assurances can the Minister give us that unsecured creditors will not lose out as a result of this bill, even though I know that's what it's designed to try and achieve? And what mitigation is in place to protect unsecured creditors, often the SME sector in particular? The intention of new Clause 4 is to make pension scheme deficits a priority creditor in the event of insolvency and therefore due to be paid before unsecured creditors. This clause asks the government to make pension scheme deficit a priority creditor, i.e. being the first in the queue in the event of insolvency and be paid before other creditors. This can make employees' votes count and offers them some protection. It's worth remembering that pension schemes are unsecured creditors in normal circumstances. If the deficit on that is not addressed by companies, then employees face an erosion of their pension rights and the value goes down. So our amendment would help them to become a separate class in their own right and not be subsumed into the amorphous mass of unsecured creditors, and their members can vote on any restructuring plan. And this way there is a clear message to past and present employees. And I hope the Minister, again, given the nature of the debate we've had this evening and that a number of colleagues from both sides of the House have raised this, that ministers will look at this. The intention of new Clause 5 is to require mandatory discussion with trade union representatives once a company has entered the restructuring process. I understand that the US evidence shows that restructuring plans often hit employees hardest, and many of the provisions in this bill are based on US European models. Their wages can be reduced in terms of an employment changed. Many end up going on 0 hours contracts, or as we've seen recently in the case of BA being sacked and then offered worse terms and conditions when they're re-employed. The pension rights are also reduced in this case, and that could happen here in the UK. I'm sure that ministers have no intention of this being an unintended consequence of this legislation. So we would hope that the Minister would take away our idea or a similar idea and see if that can be brought in the other place. And I'm looking to the Minister for some reassurance about that, not least because my boss, the Shadow Secretary of State for Business, is particularly agitated, and rightly so, about this issue. So, as I've said, I hope the Minister will take these amendments in the constructive way in which they are proposed. I note also that there are a number of government amendments, and these seem reasonable to us. We haven't had a lot of time to study them, but I am grateful for the Minister for arranging a briefing with his officials on these earlier. So I look forward to the Minister providing us a bit more detail and assurance as we take this bill forward. Thank you.
The question is that Amendment 1 be made. Paul Scully.
Thank you, Madam Chairman. This legislation, this bill has been come up with ministerial colleagues, with the bill team who have worked through weekends, with representatives of the businesses, consumers, workers, shareholders, investors and insolvency experts, and indeed with really constructive conversations with members of the opposition from all sides of the House. And to all of those people, I just want to put on my record thank you for the constructive way that this has come about. We've had a good debate, and there are a number of issues that we need to explore now, and I'm more than happy to cover as much as I can. I see that there was an amendment on prompt payment that came up in the second reading debate that wasn't selected. But just to briefly note, as the Secretary of State said, we did make a manifesto commitment to consult on extending a range of powers to the Small Business Commissioner and to clamp down on late payment. We still plan to consult on those, extending those powers to allow the Small Business Commissioner to advocate for and support small businesses. We're keen to capture as many views as possible to ensure the policy response is the right one. And in the light of businesses having furloughed staff and other priorities, we don't believe that consulting now is the right thing. But the Government, of course, remains committed to the Prompt Payment Code. Amendment 1 that seeks to add a statement from the trade union on behalf of employees to the document that must be filed at court at the commencement of the moratorium. It's important to first note that a successful rescue will be of direct benefit to employees as it will result in jobs being saved. Requiring a statement from the trade union on behalf of employees alongside the statements from the insolvency practitioner and directors, we're not sure will add little to the process. In fact, it actually may risk publicising the company's financial problems before it had the protection from creditor action that a moratorium would bring, making rescue less likely. Employees do benefit from considerable protection in the moratorium. A moratorium isn't going to act as a bomb shelter for bad employers. As I've set out previously, wages and any redundancy payments relating to a period before as well as during the moratorium should be paid by the company. If it doesn't pay such amounts, the monitor must bring a moratorium to an end. So while legal process can't be started or continued against the company while it's in a moratorium without leave of the court, an exception is made for employment tribunal claims and other proceedings between an employer and a worker. For those reasons that I've set out, I'm not able to accept this amendment, but I hope the honourable members will therefore withdraw their amendment. But I must say, in terms of engaging with the unions, I do value the regular meetings that I have with TUC members. Indeed, I'll be speaking to them, a number of them tomorrow, as part of my regular engagement. And so I do value their input at every stage in employment rights and other issues that fall within my brief. In terms of Amendment 2, which seeks to amend the initial period, as drafted, the bill also already provides a moratorium that initially lasts for 20 business days. A company might not have finalised its plans for rescue within that time, but it still may be rescuable at that point. So if towards the end of those initial 20 business days a moratorium is still required and the company's paid certain ongoing debts that have fallen during the moratorium period, the directors of that company can file a notice at court to extend the moratorium for a further 20 business days, taking the possible time to moratorium up to 40 business days in total. And that should be sufficient for most companies for 40 business days, including small businesses, to have either prepared their plans for rescue or for it to become apparent that a rescue is not likely, at which point the moratorium should, in any case, come to an end. But we do recognise that 40 business days may not be enough, and for that reason, it's also possible for extensions beyond those 40 days to be granted. But that can only be granted with either the permission of the court or with the agreement of majority in value of pre-moratorium creditors, because that would mean a lot of forbearance for any suppliers whose debts have remained unpaid since before the